Thank you, and now our distinguished moderator will begin the panel discussion.
Well, good morning to you all. We have today three exceptional people who are laureates and who come from three different continents. And so and their life and their work has been concerned with human rights, with the promotion of justice, with the promotion of the rule of law. You've heard all about it, and they are quite extraordinary persons. And so the topic which they have been asked to talk about today is an appropriate one because it concerns the use of human rights to promote the interests of communities. It's the use of international human rights law by domestic courts. And as we have people from different parts of the world, it is right that we should have an international flavor to our discussion. It all goes back really to the second half of the last century, when the adoption of the United Nations Charter and the Human Rights Instrument which followed led to a development of a concept of human rights in many different fields, and an acknowledgement of it and an acknowledgement of its international component, with a trade of ideas between different countries and a trade of ideas between people working in that field, between judges and lawyers and academics and politicians. And with the use of the internet and globalization, that exchange has become more profound, and it's beginning to affect domestic courts in many parts of the world as judges start thinking about issues which are the same in many different parts and which express themselves the same in their own societies, and therefore we can each learn from the other. And so the topic is an appropriate one, and the order we have agreed upon amongst the three laureates is that Michael will start, Tim Coulter will follow, and then we'll have John Dugard. So, Michael, will you please begin?
Yes, as Marcella, the poet, said, and we were told of him by Ramon in his introduction of me, life is a journey, and I want to tell three little stories of my journey in relation to this issue. Back in my university days, I had, as I said, a great teacher of jurisprudence and international law, Professor Julius Stone. And he taught me the orthodox view, at least the orthodox view in common law countries, that international law was up there in the clouds about princes and kings, and national law was down there on the ground, and rarely did the universes meet. And that was the orthodox view about dualism of the two legal systems. But then in 1988, I went to a conference. It's a very good thing for judges to go to conferences, especially with legal scholars. The conference was held at Bangalore in India. It was chaired by the then recently retired Chief Justice of India, Justice Bhagwati, and one of the judges attending was a very young American judge who was then on the DC Court of Appeals, by name Ruth Bader Ginsburg. And the lesson that was taught at this conference was that in the modern age, when you look contextually, one of the things that is happening all the time is the growth of international law as statements of a conceptual kind that deal with the fundamental rights of all of us as human beings. And so I had an epiphany, and I went back to my central seat in a bench in a courtroom rather like this, sitting in Australia, in Sydney, in the busiest appellate court of Australia, and I began to get cases where this instruction was actually quite helpful. And one of them was a case of a judge, a very good judge, who had refused to allow interpretation from the mute language in court, although the court remained open. And he had said this was only on a legal matter, so there was no reason to interpret. A disempowerment of the mute applicant. And so they rushed up to the Court of Appeal, and we were very user-friendly, so we interrupted the boring case we were dealing with, And we then asked them to develop the argument. And they couldn't point to any constitutional provision in Australia. They couldn't point to any statutory provision. And the common law simply said giving an interpreter or not is a matter in the discretion of the judge. And you don't normally interfere with trial judges' discretions. So we went off, the three of us, into my chambers, and I thought Bangalore. And so I reached for the International Covenant on Civil and Political Rights, and in that covenant there's a specific provision that if a person needs an interpreter, the interpreter should be provided. And so I used that as a basis for adopting in the common law of Australia a principle that was informed by the international concept. That was regarded by a lot of judges and lawyers as sheer heresy. They were very upset. They wouldn't have been upset in most countries of the world, but in Australia and the United States, they were nodding their heads gravely. However, about 4 years later, in 1992, in the great case in the High Court of Australia, to which I hadn't at that time been appointed, the decision was made in Mabo. Mabo was the case about Aboriginal land rights. And in the way of recognising land rights for the Aboriginal people in Australia was 150 years of land law and decisions of the Privy Council and of the High Court of Australia itself. But the way the court overcame all that body of legal doctrine was to say, if that is the common law, the one thing that is clear from international law today is that you cannot discriminate against people on the basis of their race. And so the High Court of Australia, by 6 justices to 1, we are 7, decided that it could unlock the door to re-express the common law by reference to the international principles of human rights. So it was a very important decision for the Indigenous people of Australia, who are often treated very poorly in the Australian legal system. It might have been uncorrupted, but it had rules which were very poor, something like South Africa. So the third story is that during the rest of my life, including on the High Court of Australia, when cases would come up, we would refer to international human rights. And just before I left the court in 2007, we had a case about prisoners' rights and about the rights of prisoners to vote in elections. And by reference to a decision of the Canadian Supreme Court in which Justice Dugard took part, Sauvé and the Queen, and by reference to a decision of the European Court of Human Rights in Hurst against the United Kingdom, we upheld the right of prisoners to vote in the national federal elections in Australia and said that was constitutionally protected. And we interpreted our constitution by reference to these decisions. And I learned this morning that Chief Justice Chaskalson signed an opinion in the Constitutional Court of South Africa, which wasn't referred to us, which said the same as Sauvé and Hurst, which all goes to show that this is a growing body. It's a conceptual body. It doesn't bind you. It's not law, but you can use it as a source of inspiration, of information, and of context in understanding your own national law. So they're the 3 little stories of my journey in my judicial life, and I believe it's a journey that all courts of this world will take and are taking. It was taken in the United States in Lawrence, the important case on gay rights, and it will help us to avoid error and to be inspired by the stories of people everywhere.
Well, yes, that's a very nice lead-in to some comments that I would like to make. Dawn may be breaking in the United States, but generally speaking, the way is untrodden so far as changing the law that is so discriminatory against Indian and Alaska Native peoples. It's astonishing but true that the United States Supreme Court holds that the United States government is free to confiscate Indian and Alaska Native land at will without due process and without compensation. And the government does do that. They will confiscate Indian money belonging to Indian tribes. They'll confiscate it right out of the U.S. Treasury with no compensation, no due process of law, nothing. And it's based entirely on race and ancestry of the people constituting these Indian and Alaska Native nations. It's astonishing that this kind of thing could persist in the United States, but it does. It's wholly contrary to the United States Constitution, certainly contrary to the fundamental human rights principles of international law. There's more, sadly. Federal law places Indian and Alaska Native nations in a state of permanent and involuntary trusteeship without any serious accountability. Well, no one else is treated like that except for children and people who are mentally incapable. But Indian nations and Alaska Native nations are treated that way, and for the most part they have no legal recourse. Treaties or contracts can be made with Indian nations by the United States government and violated mostly at will, without any legal redress. Again, it only happens to Indian nations. The law doesn't permit it as regards anyone else. The United States government claims that it has plenary power to do as it wishes with Indian nations and their property and resources without regard to the United States Constitution. There's no one else in the borders of this country, or even without, to whom, with respect to whom the United States government claims such a power. Well, what I'm getting at is that we need to see a breaking of the dawn in the United States courts about human rights and about the relevance of human rights instruments, including the ones the United States has ratified. The United States law is, like many countries that follow the tradition of the British Commonwealth, the United States certainly ratifies international human rights instruments, but most such treaties are not self-executing. In other words, they are not a part of our domestic law that must be applied in the United States courts unless there has been action by the United States Congress to implement those obligations. Nevertheless, as the Supreme Court said, international law is part of our law. Early in this country's history, the Packet-Habanya case announced that. International law is part of our law and will be applied by the courts in proper cases. The trouble is that the courts, through their own decisions, have undermined the actual application of international human rights law. But we have the Charming Betsy case. That's the name of a schooner, Charming Betsy. It's always nice to enjoy little things like that, like this beautiful day. Dark things that we talk about, but there's a lot to enjoy anyway, isn't there? Well, the Charming Betsy says that United States statutes will be presumed to be intended to be applied and interpreted consistent with international law, not the opposite. And as has already been suggested, the United States courts do not ignore international law. In fact, there are 6 cases that the Supreme Court has decided in the last, well, it's less than a generation, in the last several years, that take international standards, international human rights into account in determining decisions they make about United States law. There's Atkins v. Virginia regarding execution of persons who are mentally retarded, Lawrence v. Texas concerning anti-sodomy statutes, Grutter v. Bollinger about affirmative action, particularly in education. In all of these cases, international standards, international law and concepts were employed. And there's more, Roper v. Simmons concerning the death penalty for convicted criminals under the age of 18, the recent Hamadan v. Rumsfeld concerning war crimes tribunals, and finally a more obscure case under the sovereign immunities, the Foreign Sovereign Immunities Act. the Supreme Court is quite right to do this. They do and they should employ international law and human rights law in the decision of cases, but more needs to be done because the United States is in fact bound by international law, particularly international human rights law, customary law, and the treaties the United States has ratified, and regardless of our domestic law in the country, but nevertheless bound by international law. Well, the United States is reviewing its position today on the Declaration on the Rights of Indigenous Peoples. Secretary of State Clinton has announced at another law school here in this city that the United States intends to resume a leadership position in regard to human rights, that it will hold itself accountable, that it will be an advocate for human rights, and that it will expect other countries to do so. I think this administration is at least mostly genuine when they say such things. But there's been a good deal of talk, not much action so far, some, and it is likely that the first official action that the United States government could take is to be the endorsement of the United Nations Declaration on the Rights of Indigenous Peoples. The United States voted against it in the General Assembly. That was under the previous administration. This one has said they are reviewing it entirely. There are 15 government agencies engaged in that review. This is a good time to speak up if you know anyone or want to send an email. Do so. You can go to our website, www.indianlaw.org. There's never a chance that I'm not going to be an advocate, but we do need to advance the rule of law. We do need to get this country moving in the right direction about human rights and to change its law about indigenous peoples. So this prize, I think, is a help in moving that forward, and I'm grateful that I have this chance to say that the Mabo decision can help us lead the way, it does lead the way.
And John, will you now talk?
Yes, thank you, Arthur. I want to address two issues affecting the relationship between international law and domestic law. First of all, relating to my South African experience, and secondly, dealing with an issue affecting the United States. First of all, as far as my South African experience is concerned, during the apartheid years, it was heresy to invoke international human rights norms in domestic courts. I recall a case in which I was involved, in which the issue was the question of separate areas zoned for different racial groups, which was a zoning system that was applied in a very discriminatory manner. And when I attacked the validity of the legislation setting up the scheme, I referred to the United Nations Charter, which prohibits discrimination based on race. And I recall that the prosecutor jumped up immediately and said, "Lord," to the judge, my learned friend is being political. This is a purely political issue, and the judge ruled me out of order. But of course things have changed dramatically in South Africa today. The new democratic dispensation, in terms of its 1996 constitution, not only allows but directs courts to refer to international human rights norms. And so today, wonder of all wonders, South African courts do refer repeatedly to international human rights norms. And I think Arthur will agree with him when I say that it is quite amazing the way in which South African judges brought up in another tradition have adjusted to the new system. The 1996 South African Constitution not only protects political and civil rights, but it also guarantees or recognizes social and economic rights, right to health, to housing, to water, to food, to work, etc. This is a novel feature of a constitution, but it does mean that the South African courts can now refer to the International Covenant on Economic and Social Rights in addition to the Covenant on Civil and Political Rights. And this has become a great issue in South Africa, the extent to which courts may review the policies of the government in respect of the provision of social services. And one case which has received considerable publicity in recent times, which my daughter Jackie has been involved, concerned the issue of the provision of water. And the issue was whether the government, the local authority, was taking reasonable steps to provide water to poor people in the Johannesburg area, or whether the court should quantify the amount of water that should be made available. And it was argued that the Committee on Economic, Social and Cultural Rights had laid down a minimum cause standard which should be applied. The courts have not accepted this. This does indicate the novel feature of the South African Constitution. Other countries have a long way to go before they allow courts to determine the question of whether governments are providing adequately in respect to social and economic rights for their people. The second question that I wish to address concerns the issue of accountability. International law is no longer satisfied with simply a declaration of standards, standard setting, but it's also determined to hold those responsible for human rights abuses accountable for their sins and crimes. We do have the International Criminal Court and a number of ad hoc tribunals that have been established in order to try people who commit international crimes, violate international human rights standards. But it is also possible for national courts to hold people accountable for the violation of international crimes and human rights standards. First of all, there is a possibility of criminal prosecution when a state court exercises universal jurisdiction over a crime committed anywhere in the world. But in the United States we have a wonderful statute, the Alien Tort Statute of 1789, which allows an American federal court to exercise jurisdiction over an international tort, an international wrong committed anywhere in the world. This is a statute which was only resurrected in the early 1980s, but in recent times it has been used to prosecute individuals and corporations who have